I'm going to present today on the World Bank accountability mechanism. If this name sounds a little bit unfamiliar, it's because the accountability mechanism was created only a year ago and has been in operation only for a few months. The new accountability mechanism contains two bodies. The first is the well-known inspection panel, which carries compliance review functions. Basically, population arms by a borrower state in a bank project, the requester can file a complaint to determine whether the bank has complied with its internal policies designed to safeguard people and the environment. So the inspection panel has been established in 1993. And the second is a new dispute resolution services body, which carries dispute resolution functions. If both the requesters and the borrower states agree to it, the parties will have the opportunity to resolve their dispute through joint fact-finding, mediation, and other similar approaches. Of note, the DRS, or the Dispute Resolution Services staff, will administer the proceedings, but an external third-party neutral will help the parties reach an agreement. If the parties are unable to arrive to come to an agreement within a year, then the complaint will be brought back to the inspection panel. The interim operating procedures of the DRS have been issued less than 2 weeks ago. And last week, the bank's board of directors approved the first case where the requesters and the borrower state are being given the option of dispute resolution. Given the novelty of the dispute resolution services, the question I will examine today is, how can the DRS benefit affected population and borrowing states, particularly in comparison to the inspection panel? The answer, unsurprisingly, is that it depends on how the interim operating procedures of the DRS are implemented and revised. Yes, revised, because the accountability mechanism is seeking comments on the DRS new procedures over the course of the next year. My view is that the overarching theme of this revision should be better addressing the inbuilt inequality of power that exists between the requester and the borrower states. My presentation has two parts. In the first part, I will compare the advantages and disadvantages of the inspection panel to those of the DRS. In the second part, I will examine a few issues with the interim operating procedures of the DRS, as these procedures are currently drafted. So I come to my first part. What are the advantages and disadvantages of the inspection panel compared to those of the DRS? In a few words, the inspection panel takes a fault-finding approach. As such, over the past 30 years, it has been very successful in holding the bank accountable and promoting institutional learning. It has been moderately successful in preventing future harms, but it has not been successful in remedying the harm already suffered by affected population. This is where the DRS comes in. It proposes a problem-solving approach to the parties. We know from the experience of accountability mechanism at other international financial institutions that the benefit of dispute resolution is simply that the harm be remedied, that the requesters be made whole. But that's not all. The requesters also get the opportunity to be heard, to look the other party in the eye. What about the disadvantages of the DRS? Well, I don't have a crystal ball, so I don't know yet how the operating procedures will be implemented or how the parties will interact with them. But academic research on other international financial institutions that propose dispute resolution is instructive about the key issues that the DRS procedures should address. For example, research on the Compliance Advisor Ombudsman of the IFC and MIGA has found that when NGOs assisted complainants with the dispute resolution process, the complaints were more likely to receive a remedy and to get to the compliance review. This makes sense because dispute resolution may not result in a fair outcome when there is an inequality of power and resources between the parties, who are often, on the one hand, local communities in developing countries, and on the other hand, borrower states and relatively powerful companies. Scholars have argued that these concerns can be addressed through measures like permitting complainants to select their own representatives to participate in the dispute resolution processes, enhancing complainants' access to information, and ensuring that the implementation of the agreement between the parties is monitored. I come to the second part of my presentation. How does the World Bank Dispute Resolution Services fare? How do its new interim procedures address the concern I've just mentioned? Here, I raised questions on three different, but in my mind related topics in the procedures. First topic, the appointment of representative by the parties. The procedures provide that the appointment is made in consultation with the DRS staff and subject to no objection of the other party. Why? The procedures also provide that the cost of representation must be borne by both parties. Again, why? Why no financial assistance to the requesters? Second topic, access to information. The procedures do not specify powers that the third-party neutral would have regarding the access to documents and material, leaving these issues to be agreed by the parties. Why? Given that the project information is typically in the hands of the borrower states, how can the DRS work if the procedures do not set out and the parties cannot manage to agree on a minimum standard of information to share? Third topic, the implementation of the parties' agreement. The procedures mention that the follow-up on the DRS on implementation is subject to the agreement of the parties. Why? How, in the absence of party agreement, will compliance be institutionally monitored? All international accountability mechanisms, except the DRS now, have monitoring authority in regards to dispute resolution. The theme of all three topics is a heavier reliance on the consent of the parties. Perhaps the many whys I have asked give the impression, I believe, that the requiring party agreement on nearly all points of procedures will not benefit affected population in borrowing states, to take the title of my presentation. And I do have some concerns about requiring the parties to agree on party representatives, on access to information, and on monitoring of implementation. For one, this could give the impression to the requesters that if they want redress, they must bend to the demand of the borrower states on all these points of procedures. It is also unrealistic, based on my limited practical experience in international dispute settlement, to assume that the parties will agree on all procedural points. For these reasons, I believe it is likely in the first year that one party will revoke its consent and the complaint will be brought back before the inspection panel. It makes sense for now to tilt the balance towards the inspection panel, given the novelty of the DRS and the role of the inspection panel in protecting the requesters. But if one truly wants the DRS to work long-term and not to become overly contentious, the final operating procedures should only require the consent of the parties broadly to dispute resolution and entrench certain minimal safeguard for the requesters, like providing them the opportunity to appoint their representatives without any consultation with the DRS staff or approbation by the borrower state. This approach would recognize the inbuilt inequality of power that exists between the parties and realize the goal that the 2020 resolution set for the new World Bank Dispute Resolution Services in the first place. Thank you.